Thank you very much, Chris. Appreciate it. And thank you, Environmental Law Institute, for allowing me to be here today with you. And for those of you on our audio line, hello. I wish I could see you, but I can't. We are here today as another installment of the ELI summer program to talk about two very important statutes that are a little bit different from the statutes you've been considering. We consider this a little bit different in that we are talking about the regulation of chemical products. We're not talking about releases into the environment so much as you have already explored in addressing clean air, clean water, and some of the other topics that have been considered to date. As Chris mentioned, my name is Lynn Bergeson, and I have been practicing chemical product law, regulation, and policy for many years. I am very passionate about this space, and I hope to share some of my enthusiasm with you because, in my view, there is no more important environmental area than the intersection of chemical regulation, chemical products, and how those products are both made as new chemical product innovations, how they are regulated, and how they can make the world a better place if they are managed appropriately, and how our regulatory systems can really innovate and motivate the inspiration and development of new chemical products that are perhaps more benign and less environmentally aggressive. What we're going to do is first give a little bit of background about the context in which we're going to consider this. And then we'll talk first about the Toxic Substances Control Act, and then move to the other federal statute that we are going to consider, the Federal Insecticide, Fungicide, and Rodenticide Act. But before we go into the granularity of these two programs, let's talk about federal chemical use laws generally. There are a number of laws that you've already considered as part of this program. The Clean Air Act, I consider these falling into the category of chemical byproduct laws. The Clean Air Act regulates chemical substances as they are emitted into the environment as either direct discharges from stacks or fugitive emissions. There are other types of chemical regulatory controls under the Clean Air Act, including the regulation of fuels and fuel additives under Section 211. That provision actually is very similar to TSCA and FIFRA in that it regulates distinct neat chemical substances. So it's a little bit of a variation in a theme from the Clean Air Act that you might have considered earlier this summer, but I note it only because even under the more traditional environmental laws, the regulation of chemicals is embedded in other environmental statutes. Also, as you know, under the Clean Air Act, ozone-depleting substances are regulated. Under the Clean Water Act, again, discrete chemical substances are regulated when they are discharged from either a direct industrial facility under a NIPDES permit or as an indirect pollutant under an indirect discharge permit under the Clean Water Act. Similarly, the Safe Drinking Water Act also regulates chemical substances in water. You considered also the Resource Conservation Recovery Act and probably touched upon CERCLA, the law that regulates and cleans up legacy discharges into the environment. And again, RCRA is another statute that regulates discharges into environmental media, largely water, contaminated soil, and so forth, and manages the appropriate and prudent disposal of materials that are discarded or reclaimed or recycled. So this is a chemical waste and disposal law, but it also regulates chemical substances, but not as a product, but rather as a result of a manufacturing process. And then there are a whole host of workplace laws that you haven't gone into at all, nor will you as part of this course, but the Occupational Safety and Health Administration regulates lots and lots of air contaminants as workplace discharges, so workers are not inadvertently exposed to chemical substances during manufacturing operations. And also EPA works very closely with OSHA in the regulation of new chemicals. There's a lot of give and take, given that new chemical substances, when they are manufactured in the work environment often give rise to exposures, and so there's a lot of toing and froing between regulatory programs that we're going to talk about under TSCA and workplace air contaminant standards and other personal protective clothing and equipment provisions that the Occupational Safety and Health Administration, along with its companion organization, NIOSH, regulate specific to workplace exposures. There are a whole host of other chemical-specific laws that we are not going to go into under the transportation provisions. For example, the Hazardous Materials Transportation Act is a very important provision or law that has very granular provisions that relate to the transport, movement from A to B of chemical materials. There are a whole host of other laws that, again, we will not talk about here, but are nonetheless very important if you as law students or practitioners or government representatives need to be aware of, because the regulation of chemical products is very diverse. And so the Consumer Product Safety Commission implements a number of statutes: the Federal Hazardous Substance Act, the Hazardous Substances in Household Products, the Consumer Product Safety Improvement Act, in particular embeds specific provisions relating to specific chemicals of which you need to be aware. And finally, the Department of Homeland Security regulates chemical facilities. The anti-terrorism standards under the CFATS provisions, again, are another area of the law, but if you choose to drop your anchor as practitioners in this space, you need to be aware of the complexity and the very intricate array of provisions under federal law that relate to chemical substances. And mind you, we are only talking about federal law. As you know, we have a much more muscular state regulatory system in place for a whole host of reasons, not the least of which is the first law we're going to talk about, TSCA, has not been amended since it was first promulgated in 1976. So it is a mature adult right now at the ripe old age of 38, and because of the paucity of what many state and other public health activists and even members of the regulated community believe to be a lack of modernization, many states have implemented state restrictions on chemical products or chemical substances as neat materials, neat meaning in its pure form. So we're only going to talk about the federal law, but as Chris said at the very beginning, this is an overview intended to be pretty basic. And I want you to be aware of the context of this space. It's complex. There are lots of provisions. We're only going to talk about federal. State law is very important. We're not going to talk about international. Lots going on there. I'm happy to respond to questions should you have any. But let's first talk about the Toxic Substances Control Act, TSCA. Not an opera, although Puccini did write a fabulous opera in TSCA, but TSCA, TSCA, is a mature federal law that has been around since 1976. And the core provisions of TSCA, those provisions relating to the management of chemical substances, has not been amended since then, which is an astonishing proposition if you think for a minute about the maturity, the innovation, and the technological developments in chemical products and chemical substances generally. There were a number of really important notable events way back in 1971, for example, that really inspired congressional interest in chemical substances, one of which was a lack of information relating to, gee, what chemicals are both imported into the United States and manufactured and distributed. I think the realization back in the early 70s is, golly, we don't have a lot of information about these substances, so we need more information and we need a better sense of government oversight regarding chemicals coming in and chemicals being distributed for both manufacturing purposes and processing purposes. What is TSCA? It really is intended to provide a safety net. It is not intended to trump other statutes like clean air, clean water. It has to be looked at as kind of a last effort to manage chemical substances. And it is unique in that it really does focus on chemicals in commerce, and it regulates new chemicals that innovators and importers and others would like to manufacture and get into commerce. And we'll talk a little bit more about how important that distinction is between new and existing, okay? Now, what are some of the core reasons for TSCA? I mentioned that back in the early 70s, it was realized that we didn't have a lot of information relating to the types, the toxicities, the exposures of chemical substances to which we as citizens were being exposed. So TSCA is intended to encourage and require manufacturers to develop adequate data on the health and environmental impacts of exposure to chemical substances. Also, it is intended to regulate chemical substances according to a standard, a safety standard. And that standard is if chemicals are believed to pose an unreasonable risk of injury, okay, not just a risk. TSCA and FIFRA are not zero-risk statutes. It can't be an unreasonable risk of injury to health or the environment. And if a chemical is deemed to pose an unreasonable risk, then TSCA authorizes the United States Environmental Protection Agency to impose actions against the possibility of imminent harm or unreasonable risk of injury. And finally, and importantly, if you think about how important innovation is in the evolution of chemical manufacturing, TSCA is intended to ensure that regulation does not unnecessarily impede technological innovation and development. And for those policy mavens on the phone and in the room, think of how important that is. Look at the chemical innovation we have going on today with respect to nanotechnology, biotechnology, synthetic biology, the interaction of all of those ologies, the regulation of renewable feedstocks as chemicals. This chemical innovation needs to be managed and regulated, so Congress really had to walk a very delicate line to ensure that regulation did not stymie technological development, because technological development can move us to a space that, in my view, and this is a personal view, not a view shared by necessarily my firm or others, but move to a space where chemicals can be inherently safer, less hazardous when disposed and used, and pose fewer environmental risks to human health and the environment. And in this day and age of relentless focus on climate change and what type of environmental footprint we're leaving, chemical innovation is essential. So think about that desire to regulate but not to impede technological development as we go through our talk here today. So far so good. Any questions? Okay. Well, let's talk about the scope of the Toxic Substances Control Act. As I mentioned, this is a federal law that is managed exclusively by the federal government. It is not one of the laws that you've talked about already when a state develops its own implementation of the Clean Water Act or the Clean Air Act. It's delegated to the states. TSCA is under the jurisdiction of the federal EPA here in Washington. And we're lucky enough to have Allison in our audience today, who is with the Office of Chemical Safety and Pollution Prevention, a group of extraordinarily gifted, talented, dedicated employees that I've worked with for many years and have enormous respect for. But TSCA is unique in that it is here in Washington. And for those of you looking at career advice, one of the reasons that I dropped my anchor in TSCA and FIFRA is because it is so Washington-centric. It isn't delegated to the states. And I've lived in Washington for a long time, and I didn't want to move. So this is the epicenter of law, policy, and all things FIFRA and TSCA. So it's a really good area to be in that regard. Okay, so it's regulated by EPA, implemented by EPA, the Office of Chemical Safety and Pollution Prevention, and many different offices within it. And it relates to chemical substances. And that includes that which is on your screen, industrial chemicals, which is defined very broadly, okay? It excludes pesticides, food additives, drugs and cosmetics and preparations. Now, the reason that's important is because we didn't talk about some of the other federal laws that are also relevant for the purposes of what regulates chemical substances. But in the industrial and agrochemical communities, it's TSCA and FIFRA respectively. The Federal Food, Drug, and Cosmetic Act regulates cosmetics, drugs, and other substances, and much depends upon the use of these chemicals, and much depends upon what stage of the process you're at in managing preparing and manufacturing these substances. We're not going to get into some of these very arcane jurisdictional issues, but in thinking of buckets, if it's an industrial chemical, if it's defined as a chemical substance, you're talking about TSCA. If it's an agrochemical and you're talking about a pesticide, you're talking about FIFRA. If you're thinking of cosmetics and food materials, you're talking about a different agency and a different law altogether, and that would be the Federal Food, Drug, and Cosmetic Act. Now, TSCA regulates both the manufacturer of the substance, okay, the Dows and the DuPonts and the BASFs of the world, and it also regulates the importers of materials, because an importer is deemed to be a manufacturer as soon as they hit the United States. So for all intents and purposes, if you're manufacturing a chemical in Asia and importing it into the United States, that importer, that entity bringing it in, is considered a manufacturer of that substance, and you are therefore subject to TSCA, okay? And people that process, say for example, BASF manufactures a chemical and then sells it to a company that processes that material into something else, either another chemical mixture or substance or into a product. TSCA also regulates that entity. So if you're a young attorney working in this space and you are wondering, how do we even know the Toxic Substances Control Act applies to me? If it relates to an industrial chemical and it's in commerce and it's relating to uses that are not otherwise excluded, like a pesticidal use or a food use or a cosmetic use, you're in until you can conclude you're not. Now, I mentioned the distinction between new and existing substances, and the reason that's important is because a very different framework applies to brand new chemical substances, and the distinction between that which is considered new versus that which is considered existing has been the subject of a lot of angst, controversy, and legislation for the past 8 years or so. But a new chemical substance is, as noted here on your materials, any chemical substance that is not included on the chemical substance list compiled and published under TSCA Section 8B. So we're going to go into that chemical inventory, as it's called, but for present purposes, way back when TSCA was kicked out by Congress in 1976, chemicals that were in commerce at that time, all a manufacturer or importer had to do was send a notice to EPA to list that chemical on this great big inventory. There was no independent de novo chemical review. There was no assessment as to whether that chemical substance posed risk. There was no analysis as to the toxicological properties or functionalities of that material. It simply got listed on an inventory. That's what an inventory is, right? So that inventory back then came up with some 78,000 or so, and don't quote me, but a whole bunch of chemicals that were in commerce at that time. That list is what is considered existing chemical substances. And if you have a chemical substance and your substance is listed on that list, for all intents and purposes, subject to a bunch of conditions I'm not going to go into here, for all intents and purposes, you're good to go on that substance. You can import it, you can purchase it, you can distribute it in commerce, you can buy it, include it in your products, because it's an existing substance and is under operation of law, you are okay, you're good to go. And it's going to be considered existing for TSCA purposes and not therefore subject to other types of review for purposes of commercial production or distribution. And that's important if you're in the business of wanting to manufacture, say, a consumer product. You look at the TSCA inventory, you see that, dibutyl ethyl whatever is listed on the inventory, it's existing. You don't have to submit any pre-market notification. You don't have to get anybody's approval. You're good to go, okay? That's really important. The TSCA inventory now has about 86,000 chemicals, a number that is often pointed to by environmental activists and public health activists with the view toward, golly, that's a lot of chemicals. 86,000 is a whole lot of chemicals, and it is, but what's wrong with that number? Anybody want to take a guess? What's wrong with that number, it's a little misleading because it's like Hotel California. Once you get on that list, you can't get off that list. So there are a lot of chemical substances that people notified and put their substance on the list, whether or not they were intending to commercially produce or distribute chemicals for any period of time. So there are a lot of chemicals that are on that list that are no longer produced or manufactured or have been withdrawn to the market, sunset, or for whatever reason are no longer in commerce. So I think we did an analysis once and concluded that maybe 50,000 in that range are probably actually in commerce, which is still a heck of a lot of chemicals, but 86,000 is a little misleading for what that's worth. Okay, what are some of the key components of TSCA? Well, first off, TSCA authorizes EPA to regulate chemical substances in a very broad way, all the way from, if it's a new chemical substance, to reviewing it and assuring that it meets certain safety standards before it can be marketed in the United States, to banning a chemical substance completely if a chemical is perceived to pose unreasonable risk that cannot be abated through any other regulatory means. TSCA authorizes EPA to require industry to test chemical substances. So we're going to go through this so you know the breadth of the authority that EPA has under existing TSCA provisions. It also authorizes EPA to exercise regulatory control over the introduction of chemicals into the market. And finally, it contains a lot of record-keeping requirements that I think EPA manages very efficiently and very well, but if you are in the chemical community and don't comply with these record-keeping requirements, it can get you in some hot water. Here's just a real broad overview of the key provisions. We are not, and you're probably thinking, thank God, going to go through all of these in great detail, but chemical testing, what all does that mean? New chemicals, very important. Section 6 is the regulation of existing chemical substances. We'll go a little bit into that. Imminent hazards is under Section 7. All of these record-keeping and reporting requirements that are very important is under Section 8. There's an interesting provision under Section 9, which is relationship with other laws, which EPA often coordinates with the Occupational Safety and Health Administration and FDA when there are jurisdictional issues like who's going to regulate this chemical in this use and how can we ensure that we are covering all of the different spaces in which a chemical might be applied. Section 14 deals with confidential business information and the disclosure of information. There are very important provisions under TSCA that relate to the claiming of information as confidential, which will not be subject to public review. And those are important provisions that have given rise to a lot of debate of late as to, well, if it's a chemical substance and it relates to toxicity and other types of information that I, as a consumer and citizen, may wish to know, why can't I have access to that information? So EPA has done, I think, a very good job of balancing right-to-know issues with the need to maintain proprietary information for chemical innovators that don't wish to give away their years of innovation and toxicity testing and related information in ways that would be commercially disadvantageous to them. So why don't we start with information gathering, and we're going to start with that provision, not because it's at the beginning of the TSCA food chain, but rather if you have a sense of what type of information EPA has, it gives rise to some of the authorities that EPA is authorized to exercise based on that information. So as I noted, Section 8 is very important because it authorizes EPA to compel the submission of information that, as you will see, you can readily appreciate that EPA would be interested in having. For example, Section 8 authorizes EPA to require producers and importers of chemical substances and processors to maintain records and report information to EPA as to the chemical identity of a substance, what types of use categories it might involve. In other words, are you using this chemical for inclusion in a product? Are you using it as a chemical feedstock, as an intermediate? What kind of health and environmental information do you have on it? What kinds of people are exposed to this substance? This is information that if you look at EPA's mission to protect human health and the environment, what could be more fundamental than the identity of chemical information, health and safety, use, and how chemicals might be exposed to people and the environment? That's critically important information. So not surprisingly, EPA takes these chemical data reporting obligations very seriously, and that is the rule under TSCA Section 8. Every 4 years, chemical manufacturers have to submit forms to EPA electronically that require producers of what we call non-polymetric chemicals produced in quantities of over 25,000 pounds per chemical per facility to report information to EPA relating to production, use, exposure, and other related fields of information. If you're really interested, EPA has a fabulous website. Just go to Chemical Data Reporting on the EPA website, and you will see the specific types of information that are required to be reported. What does EPA do with this information? Well, it, number one, analyzes the information, and I know when we counsel our clients, we try to make sure that the information is reported, first off, timely, accurately, and in a way that is as aligned with the uses of the information to which we understand EPA will be putting them. And why is that important? Well, all of this information, except the fields that are claimed as confidential, are put up publicly. And so if you are a chemical manufacturer and you're manufacturing a lot of different chemicals, you want to make sure that the information that you have on that chemical is reported in a way that is as straightforward and accurate as humanly possible. Because if you report volumes that are well in excess of what you might actually be importing, processing, or releasing into the environment, that information is publicly available and might be used in a way that is not going to be commercially advantageous for your operation. So you also have an obligation, of course, to submit all information in a way that is accurate and truthful under federal reporting obligations. But recognize, too, that the information EPA obtains from this reporting obligation is critical to its mission. And so if there is information that EPA might regard as funky or a little bit weird for one reason or another, it could give rise to further scrutiny, and understandably so. So you just need to make sure that when you meet your Section 8 obligations on this chemical data reporting obligation, which is very important, you do so in a way that is timely and accurate. This is just an overview, very, very simple schematic of the types of other information that EPA is able to retrieve from chemical manufacturers, importers, and processors under Section 8. Section 8 allows EPA to collect product use and exposure information via a rulemaking. Those are very labor-intensive and don't come out a whole lot, or more popular in years past, but any type of rulemaking is very labor-intensive, takes an awful lot of time. So what EPA chiefly now relies upon is this Section 8 chemical data reporting, where companies every 4 years, and the next reporting cycle is in 2016. So if you're a chemical producer, you've got a chemical listed on the TSCA inventory, you're going to have to submit through the chemical portal that EPA maintains all of its information on your chemical. Also, companies are required to retain, you're not required to submit, but if there is an allegation of an adverse effect relating to a chemical that you produce, you are required to maintain a file of these allegations. So a worker comes up to you and says, I have a very weird rash, I didn't have it before. I think it's relating to the exposure that I sustain manufacturing this chemical. You aren't required to submit that information. You're required to retain records of it. So if EPA asks for it, you are able to do so. And if you're a chemical manufacturer, what do you want to do with that information? Put aside whether it's required by law. If a worker or a downstream customer or a producer or a customer comes to you and says, something happened in response to my handling this substance, you want that information so you can respond to it meaningfully and appropriately. So it's not just a record-keeping obligation, it's a stewardship opportunity to make sure that the product you are making is not posing any type of risk of which you are unaware and haven't already addressed, okay? What about Section 8D? Well, that allows EPA to collect information on existing substances via a rulemaking. And there will be a Federal Register notice saying, we want you producers of chemical X to submit this type of information by this date. Now, if that happens, what does that tell you? If the federal government puts in the Federal Register a request for information on a particular chemical? Just take a guess.
We have a concern.
You got a concern. So if you are a chemical manufacturer and you see your chemical in the Federal Register, probably not the greatest news, but it means that you need to be aware of EPA's interest in this chemical for whatever reason. And not say, well, hell, we'll just submit the notice and move on. It means that the agency is looking at this chemical with a view toward perhaps future regulation. And that inspires in this space a whole cascading set of considerations relating to how is this chemical being used? Is it going into consumer products? Do I have to worry about consumer liability, product liability, toxic tort? Is EPA concerned because of releases of this substance into the environment? Might there be a water toxicity concern? Is it contaminating media in a way that could give rise to an adverse effect by something that has a pulse? And if that's true, you need to take note of that and be aware of the consequences of that. Because in this day and age of social media, when there is a concern expressed about a chemical, whether or not it's validated or corroborated or proven to a point of scientific certainty, it has a consequence. And reputationally, your commitment to product stewardship, your commitment to your shareholders, your commitment to your customers need to be managed. So that's why an 8D notice in the Federal Register is a whole lot more important than just submitting information in response to it, okay? And finally, there's another very important requirement relating to 8E. 8E is companies must immediately report, not 2 months from now, not after you've decided to a scientific certainty that a particular toxicological data point is proven to be true. You are required immediately, i.e. within 30 days, to report substantial risk information to EPA. And it's information, okay? It's not a legal conclusion. And there are exceptions to this if it's already known to EPA. It's a very kind of complicated area, but the bottom line is if you're working for a company, this is an important obligation. This is an important notice that EPA needs to have immediately because the agency takes 8E information very seriously. Report immediately, substantial risk. You know, that's a literal, any information related to it. Okay, so here we've got another continuing down our lane down chemical data information collection. You've got all of these rules. EPA collects the information. Well, what does it do with this information? Say it has a lot of information collected under Section 8A of the chemical data reporting and additional information under 8C. Now with all of the computer horsepower that the agency has and all of the information it is able to analyze much more quickly than in years past, the agency is able to collect this information and make informed judgments about whether certain existing data or certain existing substances might require some form of management. So TSCA Section 4 gives EPA the authority to require additional information on particular existing chemical substances. And that's why Section 4 is an important provision under TSCA because it compels chemical producers, which include manufacturers, to generate data on a chemical substance. Now, Section 4 can take many different forms, but in years past, when Section 4 test rules, as they are called, were more regularly issued than they are now, EPA has to meet a certain standard, and the chemical substance or mixture has to present or may present an unreasonable risk, which is a hazard risk finding, or the chemical will be produced in substantial quantities and either enter the environment in substantial quantities or lead to significant human exposure, and there are inadequate data for use and risk assessment. Now, we don't have to unpack this legal standard in granular detail because there are maybe 20 different federal cases that have done that for you. And if you are so interested, there's a whole body of law on what the standard is for triggering EPA's ability lawfully and in a sustainable manner to compel manufacturers to produce toxicological or other data on an existing substance. And why is this a big deal? It's a big deal because usually these data are very expensive to produce. And when you produce data, they have to be done according to guidelines, which take a long time to develop protocols, identify which substance, is it the chemical that is manufactured, is it the chemical that's actually found in a product that is giving rise to exposure in the real world. Who produces these data? What if there are 5 chemical producers and only 3 of them step up and subsidize the $3 million that it might cost to produce these data? So there are commercial sensitivities, there are antitrust sensitivities, there are business implications, and of course, if you're a manufacturer of a chemical substance, what's the last thing you want to learn 5 years, 10 years, 15 years after you've been producing a chemical and distributing it in commerce? The last thing you want to learn is that it's causing an adverse effect in a way that you did not appreciate. Now, EPA needs to know that, and producers really need to know that, because if you are manufacturing a substance, you want to know what all of its consequences are. And so Section 4, based on information that EPA has or is in the process of obtaining, authorizes the federal government to say, you know, we think there's something funky here with respect to developmental toxicity. We want you to develop a data package on this to demonstrate that your chemical is not causing this type of harm. And this legal standard is the standard that EPA must meet in order to compel that data production. Okay? Now, Section 4 test rules are not as common as they used to be, and EPA now prefers to either hope that companies voluntarily produce the data, and there have been a number of voluntary data production programs, or that a consent order is issued and you negotiate a testing package where companies that are manufacturing a substance get together and negotiate with EPA on what needs to be produced, by when, and by what standard. Allison, you had a question.
Yeah, thank you. I'm curious about what type of peer reviews there would be. It seems like just on the surface there's a conflict of interest of manufacturers developing their own health studies for the products and chemicals they're making.
Okay, Allison has asked what type of peer review exists with respect to the output of a Section 4 test rule or an enforceable consent agreement. And I think the answer is EPA is very much involved in the identification of the testing protocol, the laboratory that is undertaking the test. A lot of these guidelines are required under the OECD testing guidelines. The agency is very familiar with them. So regardless of who's paying for it, if the study is done according to guideline and is being negotiated with EPA and the results are made available to EPA, it's not so much who's doing the data generation, but who is interpreting the result and how is that data result interpreted in a way that might give rise to either additional testing or the application of regulatory controls on the chemical that is being produced. So there's an awful lot of stuff out there in cyberspace regarding to data quality, how do you interpret data, Can we have a peer review panel that is independent and unrelated to the generation of those data, interpret them? And that's really where the interpretation and data review comes in, not so much how the data are being generated, because that's clearly done according to standards that are independently known, but rather how are those data being interpreted and what do they mean? Okay? With respect to chemical testing, all rules undergo economic analysis and are subject to public notice and comment. Again, so if EPA issues a Federal Register notice saying you have to generate X number of tests on chemical X, that is all part of a federal rulemaking, and anyone and all stakeholders are invited to participate in it, and it's all public and open. You have to, as I said, adhere to published test guidelines. These are not insubstantial guidelines. They are regulated in the Code of Federal Regulations. And as I mentioned, often because rules take an awful long time, 5 to 7 years to crank out, EPA has rather proposed a Section 4 test rule in the Federal Register, and then often producers, rather than go through the angst, the time, and the money of having the agency issue a final finding, which chemical producers can understandably wish to avoid, they will agree instead to discharge that testing under the terms of an enforceable consent agreement, which is a contract between EPA and the producers to generate certain data by date certain. Okay? So moving down our paradigm here, we've got the inventory maintained under TSCA 8. We've got all these record-keeping reporting obligations. If the EPA finds that additional data are needed, it has the authority to compel those data. What if EPA, after these data are produced, finds that there is a problem? Well, the agency under Section 6 has the authority to address an unreasonable risk through chemical restrictions, warning labels, record keeping, and even product bans. So let's just talk a little bit about the authority that EPA has under Section 6, because this is an important provision and has been subject to quite a lot of debate over the years. Specific list of risk management options identified are, as I noted, labeling. EPA might require that a product manufacturer put on their product label warning this chemical substance could give rise to X, Y, and Z, and you need to manage it or maintain these management practices in managing the chemical. It might have additional record-keeping requirements in addition to those that we have already considered. So you could have very specific record-keeping requirements if EPA finds there's an unreasonable risk with this chemical and it exercises its authority under TSCA Section 6. It can have a specific use restriction saying, you can manufacture this chemical, but you can't use it in this application because this application gives rise to unreasonable risks, and therefore, in discharging our Section 6 authority, we are going to limit that unreasonable risk by taking that application off the label. And of course, the agency can ban a chemical. EPA's ability to do so has not been terribly successful. You might hear in the TSCA debates of late in TSCA reauthorization and reform, corrosion-proof fittings. That's the 1991 case where the agency tried to ban asbestos in certain applications, and it was challenged in court. And the court found that EPA did not meet its legal burden under the Section 6 law or provision, and hence it was invalidated. And many people think, oh my goodness, if EPA can't ban asbestos, what the heck can it ban? And might the standard under TSCA Section 6 be too restrictive to be a meaningful tool in the EPA's toolbox? So what is the standard under Section 6? Well, EPA has to demonstrate that one or more of the activities involving a substance or mixture presents or will present an unreasonable risk. Okay, that's number one. And importantly, and this is tricky, EPA has to evaluate all health and environmental effects, exposures, the benefit of the substance, the ability and availability of substitutes to perform the same functionality as that substance, and the economic effects of the alternative, and the elimination of the chemical that is giving rise to the unreasonable effect. and EPA must choose under the existing Section 6 standard the least burdensome form of regulation and balance the cost and benefits of that election. Now that's a tall order, and it's a standard that has proven to be difficult to satisfy. And if anybody is really interested in this, I would urge you to look at the decision in the corrosion-proof fittings, because the court went through a very laborious, disciplined review of each element of the Section 6 standard. And the one that has proven to be a little bit elusive has been this least burdensome option in light of the cost-benefit analysis that is required. In actions from prohibitions to risk communications and use of consent orders, EPA must demonstrate that one or more of the activities involving a substance or mixture presents or will present a reasonable risk. So this is the composite sketch of the criteria that in the legal standard that EPA must meet in exercising its authority under Section 6. So not surprisingly, this has been an area where detractors of TSCA have claimed that the burden is too high and the Section 6 authority has been too infrequently discharged, and hence it needs to be reviewed legislatively so it is a more meaningful, readily available, and less restrictive tool for EPA to regulate chemical substances. So any questions on Section 6? It's always been the subject of tremendous debate, and I didn't want to gloss over it, but it also is a very tricky legal burden where the agency has had a hard time meeting it. So let's move on to very important Section 5, new chemical review. Remember we talked about the distinction between existing chemicals, all of those chemicals that are found to be on the TSCA inventory that have been in commerce when TSCA was first implemented back in the late 70s. Well, if you were not on that list of chemical substances and you want to manufacture a chemical, you've got a brand new substance that is extraordinarily functional, cheap to produce, and will make the world a better place, do you get to just pop it off into the environment without any type of review? No. Section 5 requires pre-manufacture review for all chemicals that are deemed to be new. And what is a new chemical substance? Shout it out, anybody. It's any chemical that isn't on the list and needs to be. Some chemicals aren't on the list because they're exempt. But if it's not exempt and you want to use it for commercial purposes and it's not on the inventory, you have an affirmative obligation to submit a notice to EPA so the agency has an opportunity to check it out. Very sophisticated process that the agency has. And we're going to talk just a little bit about what that process is, because this is where I do a lot of my work and I love it. So chemical substances that are not on the list and are considered new must be notified to EPA under the pre-manufacture notice, or PMN. If anybody can tell me what that chemical substance is there on the screen, I will give you this book, Toxic Substances Control Act. It has everything you ever wanted to know about TSCA but were afraid to ask. Anybody notice take a wild guess. It's something that you drink copious amounts of when you don't want to fall asleep. Caffeine, that's what it is. I didn't recognize it either, so don't feel bad. Okay, so not that caffeine is new, but let's just pretend you've got a new chemical substance. You submit this notice, which is a form. You can, again, go to EPA's website and download a pre-manufacture notice form. And it's not just 2 or 3 pages. Not surprisingly, EPA requires that you submit all information that you have on it. You're not required to generate new information, which is another sore point with TSCA. You're not required, for example, to submit a minimum data set regarding your new chemical. But if you have toxicological information, you got to give it to EPA, okay? So you describe the chemical, what types of volumes you're going to be producing, intended categories of use, any byproduct, because even though you're manufacturing this chemical, what if in the process of manufacturing that chemical, you're manufacturing a pretty nasty byproduct? EPA wants to know about it. The molecular formula, and any other, as I said, available information. So what happens then? EPA takes the information, and it goes through a very well tried and true, sophisticated review by EPA, scientists and regulatory experts. Now, under the law, if you submit your PMN, the agency is required to address that PMN within 90 days of its being submitted. And that's good news, because if you have just spent $10 million developing a brand new chemical and you want to market it, you can't just pop it off. You have to submit your pre-manufacture notice to EPA to allow the agency an opportunity to assess whether there might be opportunities for an unreasonable adverse effect on human health and the environment caused by this chemical, okay? Now, there's a manual, if you're really, really interested in this, that EPA will go through all of the different structural activity team reviews, the economic analysis, the environmental fate analysis, how the chemical is analyzed if you don't have actual toxicological data, what structural activity analysis and chemical analog EPA will use. So there are lots and lots of opportunities on EPA's very good website to learn what goes on behind the curtain during this 90-day review period, okay? But EPA does review health effects, environmental fate, and because not surprisingly, EPA has an abiding interest in ensuring that that new chemical does not cause harm. And you, as a producer or ultimate purchaser of that chemical and processor of it, you have an interest of ensuring that something does not give rise to harm. So the review process is very sophisticated by EPA. It uses a lot of these models in the absence of actual data, because as I said, a lot of people get pretty grouchy over the fact that if you're manufacturing a new chemical, you're not required to submit a minimum data set. And people say, well, good Lord, how on earth can EPA check and assure that it's safe? And it does so by its use of models that predict the toxicity of chemicals based on data it does have, using predictive technologies and methodologies that are tried and true and very sophisticated. So what happens at the end of this process? So you're getting to be around day 80, 85, you haven't heard from EPA. You know, on the 90th day, if you haven't heard from EPA, it is presumed to be okay. It's not like the agency will call you up and say, hey, guess what? Your chemical is approved. This is not an approval process. This is a review and notification process. So if after that period of time, EPA has a number of options it can pursue, and that's why there's a multi-arrow fork here. EPA can drop the PMN and determine that there are no issues associated with it and you're good to go. It can require that it's generally okay, but it's going to apply some restrictions on it to address a particular risk that is found either in the workplace or in other applications. It can not allow the PMN to go forward at all, just say, you know, we really think you ought to withdraw this chemical because we have significant concerns with it, and there are commercial reasons why you may wish to do that. But basically, this 90-day review process is authorized and entitled and intended to give EPA an opportunity to check it out. So if at the end of that 90 days, you haven't heard from EPA, I always call the agency and check to say, are we good to go? Just in case that something got goobered up. But if you are good to go, does that end of the 90-day put your chemical on the inventory? Do you magically morph into an existing chemical? No. You have to submit what is called a notice of commencement. And that is that act, the NOC, that actually puts your chemical substance on that inventory, and you are magically transformed from a new chemical substance to an existing one, okay? This is just a further explanation of the new chemical review process. No action. You might want to say, geez, EPA had a lot of problems with this. I think I'm going to withdraw it and go back to the drawing board. And you might be able to address some of these issues in ways that will give rise to a more optimistic regulatory review outcome. The EPA has authority under TSCA Section 5 to limit, prohibit, or otherwise impose restrictions, as I said, and it's through the mechanism of either a non-5E significant new use rule or a 5E order that EPA discharges this authority. And again, we can get into some very granular detail here, which we're not going to do, but suffice it to say that under TSCA Section 5, EPA has a wide variety of tools through Section 5E to limit, restrict, or otherwise ensure that a new chemical substance is manufactured and used and distributed in ways that do not cause unreasonable adverse effects on human health or the environment. And they can be done through 5E orders, consent orders that require some sort of exposure mitigation, testing, labeling. There might be hazard communication obligations. So again, it's kind of an intuitive process that if you think through, the agency's job is to make sure that chemicals do not pose harm, and what are the tools EPA has to ensure that it doesn't do so, and these are some of those tools. Here's additional information on what are called significant new use rules. These are, again, outcomes of the review process that enables EPA to limit and ensure that new chemicals, when manufactured and used as intended, do not give rise to harm. There are many that are issued these days because the agency's review process under the PMN program is very sophisticated, and there's not a lot that gets by EPA when it relies upon either the information provided or its sophisticated structural activity relationship analog predictive methodologies. So I feel very good about the agency's experience, even in the absence of a requirement to produce data. The agency's methodologies and review of new chemicals are so sophisticated and so predictive that chemicals that do or are believed to pose the types of harms that TSCA was intended to address are being captured at that level. Getting back to that 90 days, anyone who wishes to manufacture or import a chemical substance that is subject to a significant new use rule may do so long as the conditions of that significant new use rule are being addressed. So in other words, if you want to manufacture a chemical substance identical to that which is the subject of a significant new use rule, you may do so without further regulatory review by EPA. If you wish to deviate from the conditions of the significant new use rule, you have to submit what is called a SNUN, a significant new use notification. A SNUN is nothing more than a PMN for a chemical substance that is subject to a SNUR. And again, we can get bogged down in all of this nomenclature, and I don't want to do that. I don't want to lose you. I just want you to leave with the notion that if you have an existing or a new chemical substance, EPA's review of it is sophisticated and thorough. If conditions are applied to that new chemical through the operation of a significant new use rule, other chemical manufacturers after that review can similarly manufacture that chemical, provided they don't deviate from the conditions set out in this SNUR. And if you do deviate, you're essentially saying, I've got a new chemical for which the agency needs to review that new use, and you do that through a significant new use notification, which is basically a PMN, okay? So it's really very straightforward. Now, there are lots of other really important functionalities that the Office of Pollution Prevention and Toxics maintains, and I put a picture here of Wendy Cleland-Hemnett, the current office director, who just does a fabulous job. But EPA's Toxics Office is not just about regulating chemicals that are believed to pose risk. EPA is also about promoting and incentivizing the manufacture of new, greener, more benign chemicals, and of ensuring that pollution prevention is promoted. So there are many different functionalities, and I think under Jim Jones's leadership, who is current assistant administrator of the Office of Chemical Safety and Pollution Prevention, there's been a lot of emphasis on incentivizing the production of new innovative technologies and chemicals to ensure that the agency's mission is fulfilled. So promoting pollution prevention is a very important part of the Office of Chemical Safety and Pollution Prevention. Promoting safer chemicals is super important. Jim and his colleagues, Wendy, Dr. Doa, Barbara Cunningham, all of these folks at EPA are doing a really good job of promoting safer chemicals and utilizing existing TSCA authorities in ways that promote green chemistry. Promoting risk reduction to minimize exposure to existing substances, such some of our legacy chemicals like asbestos, dioxin, and PCBs. Those are mature chemicals that EPA has done a very good job of regulating in a way that maximizes their essential uses, but prevents further distribution and commerce in ways that might give rise to harm. And also, EPA does a very good job of communicating risk, because as I said at the very beginning, this train collision between right to know and confidential business information is really crystallized in many TSCA opportunities and TSCA regulatory requirements and submissions. So EPA, I think, does a very good job of balancing right to know. You know, you're a citizen, you're purchasing chemicals, you have a right to know what's the toxicological properties of that chemical. But as a manufacturer and an innovator and an entity that spent $1 billion in innovating a new molecule, you have a right to the protection of that intellectual property so it is not misused by foreign entities or local competitors in ways that undermines your ability and desire to generate new chemistries. So there's a lot going on in the Office of Chemical Safety and Pollution Prevention beyond just merely regulating toxic chemicals. Other important program offices include the National Program Chemicals Office that deal with these legacy molecules of lead, mercury, dioxins, and PCBs. The Pollution Prevention Act of 1991 is often mentioned in close proximity to the Toxic Substances Control Act in authorizing EPA to undertake certain actions in response to chemical substances. EPA is Design for the Environment, a super important program. I would urge you, if you're interested in this space, to look at EPA's website, because the DFE program is very important in working. The agency works with chemical producers in various sectors to ensure that newer chemicals or existing chemicals that have been proven to not give rise to the types of harms that TSCA is intended to prevent are utilized and maximized to the greatest extent possible. And if you achieve the standard under the DFE, you get to put a logo on your product, which I think is very attractive to chemical producers and product manufacturers in demonstrating the safety of their products. So that's really been a very important component of the OPPT and Office of Chemical Safety and Pollution Prevention. And finally, the agency's commitment to green chemistry is really important. The EPA sponsors each year a presidential award for rewarding, recognizing, and promoting new molecules that are believed to be greener, safer, better, and pose fewer risks than perhaps chemicals that they are replacing. And the agency's acknowledgement of these molecules and the notoriety they receive each year is just more and more important. A lot of our clients compete each year to be bestowed a Presidential Green Chemistry Award, because to be a recipient of that award really means a lot in terms of the safety of your molecule, what it is, and who's standing behind it. Any questions with regard to Section 8, Section 4, 5, 6? We're really not going to talk a lot about the enforcement stuff. I talk a little bit more about FIFRA, but recognize that TSCA has very significant penalties. I talked a little bit about that chemical data reporting requirement. That is a target-rich area. If you do not submit your form timely, if at all, or incorrectly, you are going to be looking at enforcement consequences, which include administrative citations, civil lawsuits, and criminal penalties. So I think the TSCA, the record-keeping reporting, very important. manufacturing, importing, distributing a chemical that is not considered existing and not on the inventory, you're going to be looking at enforcement consequences. So it's very important, if you are in this space, to be manufacturing, importing, and distributing chemicals that are authorized, that are listed on the inventory, or you have determined do not need to be on the inventory because they're research and development chemicals, they're polymers, and fall below a threshold of toxicity that EPA has presumptively decided is not worthy of chemical notification, or other exemptions apply. So there are very stiff penalties relating to non-compliance. Let me just end TSCA before going to questions on a couple of current concerns with TSCA. I've already mentioned a lot of them. What do you mean I get to manufacture a new chemical substance without submitting a minimum data set to EPA? That is true. But that doesn't mean EPA doesn't have information. It just means that you, as a chemical producer, are not required to produce it. The agency has very sophisticated structural activity relationship predictive analog technologies that allow it to predict what is going on. So, but that's criticism. No requirement for data generation on new chemicals under TSCA. Too few chemicals have been tested under TSCA Section 4. Well, that is a criticism. Remember TSCA Section 4 test rules, we talked about those. They're hard to get out. They take a long time. So EPA has really defaulted into enforceable consent agreements or voluntary data production programs like the high production volume program that was ushered into vogue and sunset a number of years ago, that chemical producers of high production volume were required to submit data, or urged to submit data, excuse me, not required, it was a voluntary program. So there are voluntary programs that the EPA has pursued in light of the difficulty sustained under maintaining a TSCA Section 4 test rule. When the too few chemicals are regulated under TSCA Section 6, remember that really high burden, the least burdensome requirement? Yeah, it is a hard standard to meet. It's not impossible, but it's tough. But EPA has not exercised a lot of authority under TSCA Section 6 because the corrosion-proof fittings case has proven to be kind of a downer. What about it's too easy to claim confidential information? I think EPA has really gotten a handle on that and has been, both industry is much more disciplined now in asserting a claim of CBI, recognizing that you need to corroborate that. You just can't call any darn thing CBI because you don't want it to be disclosed. You have to meet certain standards that this information has never been disclosed before. It is material to the uniqueness of your molecule, and that release of that information is going to be catastrophically important, and it doesn't include health and safety information. So it's too easy to claim CBI is, I think, a problem that is not as urgent as it used to be. So all of these concerns have fueled demands for TSCA reform. There have been many legislative efforts to reform TSCA. In 2013 and earlier this year, there was a bipartisan Senate approach with Senator Lautenberg, who of course passed away, and Senator Vitter came together to propose a bipartisan Senate bill for the reform of TSCA. It didn't happen, and it won't happen this year. We might get luckier in the 115th Congress next year. But given the fact that we're looking at midterm elections in a few short months, there will be no TSCA reform this year, period. Whether there will be next year in the shadow of a presidential election, I have my doubts, but so much depends upon the composition of the House and Senate after the midterm election, so we will see. But I didn't want to go into TSCA reform any more than that. We have lots of information on TSCA reform efforts listed on our website, a whole compendium of efforts going back several years. I think it's suffice to say that it's a work in progress. And even in the absence of TSCA reform, Jim Jones and EPA have done a terrific job of maximizing the authorities the agency has under TSCA right here, right now, in ways that have given expression to some of the demands for TSCA, and many of the issues that have been supporting those demands have been addressed through those measures. So I will open it up to Q&A now, and this gentleman in the front row.
So is there any provision in TSCA
Okay, the gentleman asked, is there any provision in TSCA that would require or impose retroactive liability on an entity subject to TSCA, right? Well, in some respects, there's retroactive liability in the form of liability if you didn't do something you should have done under TSCA, like failure to submit a pre-manufacturer notification. That would require that you immediately stop production of that chemical. It would require your payment of almost certain penalties for manufacturing a chemical that has not been approved. You most certainly could be liable for some of your downstream customers for supplying a chemical that was non-compliant with TSCA, and you might have made reps and warranties in your commercial arrangements. And obviously, if you are no longer authorized to supply a chemical substance and your downstream customer is reliant on it, you almost certainly are looking at commercial liability for failure to sustain your supply agreement and breach of contract. But TSCA doesn't have any type of retroactive liability in the form of cleanup or any of the authorities that EPA has under the Comprehensive Environmental Response Compensation Liability Act, for example. It's not like that. But there are other forms of liability for failure to adhere to TSCA that almost have that effect in the form of correcting a harm that has been addressed, and it might inspire other legal authorities, tort liability, product liability, commercial liability, that give rise to some of those same types of consequences. Okay? Other questions from our audience here? Yeah, I've got a couple of questions. Here's a question received from our viewing or our listening audience. Is there something in the conference room that contains a chemical you can tell a TSCA story about? Well, of course. If anybody has, well, every article in this room contains a chemical substance. And the whole concept of articles is a subject of enormous interest right now with EPA. For example, this picture is an article because it's been conformed to meet a specific shape and is a composition of many different chemical substances. It contains plastic. Plastic has been the subject of innumerable chemical reviews and other types of TSCA notifications because they might be new chemicals or existing chemicals for which, for which additional scrutiny has applied. So everything that we touch, we see, we feel, we experience, whether they're the cosmetics that we use in the morning, some of us anyway, gentlemen, or the paints on the walls are all subject to TSCA in some form earlier in the value chain. I wanted to circle back to the fact pattern of the Elk River chemical spill, because I think that gives rise to an interesting debate that occurred at that time. I remember I was called a number of times by a reporter from the Wall Street Journal trying to understand how could it be that a chemical substance that it was manufactured in copious quantities and stored in large tanks along the banks of the river there in Charleston, West Virginia, that so little toxicological or environmental fate information was known about it. And I think that spill really crystallized some of the ongoing concerns with existing TSCA and the inability of chemical producers to sometimes demonstrate that they have a lot of toxicological information or environmental fate information about the chemicals they produce. But remember, this was one of those chemicals, the one that is at issue here, the MCHM, was a chemical considered existing because it was in commerce when TSCA was first issued back in the mid-70s. So somebody notified EPA of MCMH, it got on the inventory, and after that, there was no further scrutiny of the chemical, and of course it became a household word when in January of this year, over 10,000 gallons of it spilled into the river, and cause multiple downstream effects to the area residents in Charleston, West Virginia. And EPA and the West Virginia authorities and the CDC had very little information to say, gee, I can smell it. It was coming up through some of the sewer lines in the plumbing system of homes. I can smell it. I know it's there, but I don't know if it's causing any adverse effects, and how come that is the case. So it's a very good example of a real-world situation where the limitations of TSCA were brought to the fore, because when EPA looked back, and the Charleston folks looked back, and even the owner of this tank farm looked back, they discovered they had very little information to share with regard to whether or not exposure to this chemical was likely to give rise to an adverse human health or environmental effect. So would TSCA reform address some of these data deficiencies? Perhaps, but that's part of the debate. Would EPA have the authority to compel the production of additional information on this chemical? Well, if EPA thought it could issue a TSCA Section 4 test rule, but it probably has concluded that either too little of it is manufactured or the circumstances of this release were too unique to give rise to a separate rulemaking. But it does give a very good example of the disconnects in too little information known about existing chemical substances and the limitations on EPA's authority to compel the production of that information. Getting back to the question that was raised, is there likely to be a chemical or substance in carpet, furniture, or equipment that went through an approval process that I can tell you about? Well, sure. There are lots of different chemical substances that EPA has looked at that have been applied to textiles, for example. EPA a number of years ago expressed concern with some class of chemicals in the PFOA line. These are chemicals that were thought to give rise to adverse human health effects at exposure levels that were found to be relevant in some commercial products. The coatings of either some of the waxy paper on pizza boxes, stain-resistant fabrics, all might have contained, in some instances, a chemical that EPA found could give rise to adverse effects. So the agency really engaged in a process, a voluntary process, under its authority pursuant to TSCA Section 5 and 6, where chemical producers came together, demonstrated to EPA that the chemical did or did not give rise to adverse effects, and it ultimately resulted in a program that the manufacturers of these chemicals diminished by a date certain the quantities of these chemicals in products, both in production and of course then in the products in which they were ultimately included, to ensure that this class of chemicals did not give rise to harm when they were used in textile applications to prevent the stains from forming. That was one of the uses, or use in papers that were intended to prevent sticking, products from sticking. So there are all kinds of products in use today that the agency has been very vigilant in ensuring that if they contain certain chemicals, they don't give rise to human health or the environment by prohibiting their use or compelling the production of additional information to give rise to these, more information about these chemicals to limit their production or preclude their use in certain applications that might give rise to the greatest exposures. So are any other questions that are coming in? Okay, well, let's turn and devote the remaining 40 minutes to the other chemical product law that we don't go into as much detail because it's even a more arcane, quirky statute called the Federal Insecticide, Fungicide, and Rodenticide Act. Like TSCA, FIFRA is implemented by the Office of Pesticide Programs, which is headquartered across the river in Crystal City. And there are multiple divisions here. And the pesticide world is actually very diverse. You think of pesticides, well, they're just out there. There are a whole bunch of different kinds of pesticides, antimicrobials, rodenticides, all of which give rise to different types of properties and considerations with respect to their use and exposure. And what's a fundamental difference between a pesticide and an industrial chemical? Just off the top of your head, what can you tell me about intuitively? How are they different? Yes.
An insecticide is intended to kill something?
That is exactly right. The response was, well, gosh, and insecticides, pesticides are designed to kill. That's exactly right. And so, not surprisingly, EPA has a very strict program because these are chemicals that are intended to achieve exactly what they're used for, which is to kill something or mitigate or repel. Whereas industrial chemicals are not intended. They don't, in all cases, have a biological effect. And they're also used in industrial context where workers who are most exposed have protective clothing and equipment, Tyvek gloves, face masks, forced air respirators, or other types of controls, hooded exposure production lines to prevent exposure. So many different fundamental differences between intended toxicants discharged into the environment with the intent to kill versus an industrial chemical that is not used to kill but could give rise to adverse effects, but often the first line of exposure are people most protected, okay? Another fact that it draws TSCA and FIFRA together is that, like TSCA, FIFRA is a risk-benefit statute. Remember, TSCA, as I said, was not intended to eliminate risk. It was to prevent unreasonable risk. And likewise, FIFRA is not a zero-risk statute. Of course there's risk, but that risk is outweighed by the benefits of the properties and uses of the chemical. So another parallel similar to TSCA is FIFRA is managed principally by the EPA here in Washington. But there are some states that have pretty mature state statutes where they can require additional data on top of what the federal government requires under FIFRA, and those states are California, certainly, New York and Florida. Florida, because it's such a high groundwater table and a very active citrus market, the application of chemicals there has inspired a very robust state program that prevents the application of chemicals that could compromise the water quality while we're growing oranges and lemons and other citrus types of commodities. So recognize that it's a federal program, but states have a very important role often in enforcing FIFRA, but only a handful of states have separate programs, but all states have a separate licensing requirement. Another interesting quirk about FIFRA is that it really is a licensing law. You get a license to kill, as it were, by getting your FIFRA registration. And in every state, after you get your federal license, you have to get a state label. In almost all cases, except the states that I just mentioned, it's a ministerial act of just getting your label approved. You pay a piece of, chunk of change, and the state will give you your state label. Very important from an enforcement perspective, because if you're a pesticide manufacturer, you have a brand new mosquito spray that you want to market. You've just spent $15 million getting it approved by EPA. Can you start selling that? No. You're halfway there, but you also have to get a state label to make sure the state is aware of how you're marketing that product. Okay, so what is a pesticide? Again, it's the Federal Insecticide, Fungicide, and Rodenticide Act, and they're all considered pesticides. Well, it's any substance or mixture of substances intended for preventing, destroying, repelling, or mitigating a pest. So it's pretty broad. And a substance is required or intended to be used for a pesticidal purpose in order to trigger the application of FIFRA. If the person who distributes or sells the substance claims, states, or implies that it should be used as a pesticide. So this is where it gets a little bit squishy. And if you're in this space and if you're having to know what is a pesticide, it is a little bit on the intent side of the equation. Because there are a lot of chemicals that have a pesticidal potency. It can kill a pesticide, but you're not intending it to be that way. And similarly, you can have a chemical that you know in your heart can act as a repellent, and you're not marketing it, but everybody in the community knows it might have that pesticidal property. Well, EPA can assert that you are implying the use of that chemical as a pesticide, and that can be a violation of FIFRA. So it's very, what do you know, how are you marketing it, what claims are being made, and what is your intent? So it's very important that that be considered. Okay, what are the regulatory, just go through some of the regulatory scope here of what all is a pesticide. Well, there's active ingredients, inert ingredients, and there are special types of pesticides. What is an active ingredient? What do you think an active ingredient is when you go and you buy Roundup at Home Depot over the weekend because you can't stand the weeds that are coming up through your gravel driveway? Guilty. I'm compulsive that way, and so I use Roundup. I think it's a very effective product. It's targeted for weed control. What do you think is an active ingredient? What is an inert? Because when you look at the label on a pesticide product, we're going to go through that. It usually says 0.1% or 0.1% or 1% or 2% of something. Well, that active ingredient is the pesticide, because that's what has the pesticidal potency that gives rise to the destroying, the repelling, or the mitigating of the pest. And that pest can be a weed, it can be an insect, it can be a rodent. And there are other types of active ingredients that relate to plant regulators, defoliants, dehiscents, and nitrogen stabilizers. So there's a broad category of what is considered an AI in the business, an active ingredient. And then there is everything else in a pesticide formulation. Those are considered inerts. It can be all of the adjuvants or something that makes the chemical spread better or more effectively or stick. They don't have a pesticidal potency, but they're very important to the formulation, okay? And as I said, there are different types of pesticides. There are so-called conventional pesticides. Those have been around a while, and they are chemicals that you think of as being a fungicide to address mold and other things, or it's a class of chemicals called conventionals. Then there are minimum risk pesticides. These are pesticides that EPA is actively encouraging the development of because they have a less environmental footprint, they are less environmentally and toxicologically aggressive, and they have minimum risk. So they get a special classification, and they are entitled to certain benefits as a result of that diminished toxicity. Are biopesticides, antimicrobials, and what we call treated articles. Treated articles include, if you have a can of paint, paint often can develop mold because of the liquid content it can. And so chemicals are used as preservatives to make sure that the can of paint is not compromised by mold development before it is actually used as intended. And the inclusion of a preservative in the can of paint does not mean that the paint can itself is a pesticide. Because EPA, under the law, has taken the position under Section 25 of FIFRA that when you use a preservative or some sort of pesticide simply to preserve the integrity of the article itself, and you're not claiming that the wall has an antimicrobial value, you're not claiming that if I touch the wall it's going to kill germs on my hands, then that is considered a treated article. So that's a type of pesticide, but it is not regulated by EPA because you are not making pesticidal claims regarding the article that is treated. It is only preserving the integrity of that which is the article, okay? Now, similar to TSCA, FIFRA is very much a pre-market approval statute. It's very much risk-based. In other words, there are clear risks with pesticides because when you are intending to kill something, it's going to have a toxic potency to that chemical. But pesticides have many, many beneficial, desirable, if not essential properties for mitigating pests and public health vectors that threaten public health and safety. So there's a standard that the agency uses in ensuring that when regulating pesticides, that standard is met for purposes of allowing pesticides to enter the market. And that is, for non-food uses, there's no unreasonable risk, which sounds a whole lot like TSCA. And for food uses, if you have a chemical that is applied to a raw agricultural commodity and it could ultimately be consumed, tomatoes or apples or whatever, there's a reasonable certainty of no harm by virtue of the presence of that chemical on that commodity. So those are the legal standards that EPA measures its review of pesticides. And the burden is very much on the manufacturer or producer to demonstrate the standard is met. Now that's different from the standard under TSCA, where the burden is on the government to prove that the chemical and exposure to it could pose an unreasonable risk of harm to human health and the environment. So TSCA and FIFRA are both risk-benefit. They both allow a modicum of risk, provided the benefits are outweighed by that chemical. But there's a very clear dichotomy between TSCA and FIFRA in that the standard under FIFRA is, the burden is on the registrant itself to prove safety, whereas under TSCA, the burden is on the government to prove that the standard is not met. Another irritating factor for people who are clamoring for TSCA reform. And then also, unlike TSCA, FIFRA is very use-specific. So when you're given this license under FIFRA, that's what EPA does. It gives you a license for a time certain to release this toxin, this pesticide, this poison into the environment. And every single use of that pesticide is regulated in your registration. So it's not like TSCA where, remember we talked about that 90-day review, and after the 90-day review, your chemical gets on the inventory and you're good to go if there are no other restrictions. Under FIFRA, you can't monkey with your registration. You can't change the use pattern, you can't change the manufacturing process, you can't change the formulation, and you can't apply that pesticide to any other use or any other application except exactly what EPA has told you to, is authorized under the terms of your license. So it's very use-specific. And some people say, you know, that's like a pretty good program there under FIFRA. Why don't we have that for TSCA? Well, one of the problems is there are many fewer registered active ingredients under FIFRA than the 65,000 or so listed chemical substances on the TSCA inventory by, an order of magnitude. So there are many fewer chemicals regulated under FIFRA than there are under TSCA. So let's talk a little bit about the regulatory framework here. EPA reviews registrant submitted data against these applicable standards for food use and non-food use. So the burden is very much on a manufacturer or a foreign importer that wants to market a chemical substance as a pesticide. The requirement and the burden is on that producer to prove up the bona fides of the safety of that chemical when used as intended by virtue of meeting data requirements at 40 CFR Part 158. And there's lots of different tests. It's a very thorough, very robust program, very expensive. It's not for the weak of heart to get a chemical registered under FIFRA because the review is demanding, it's time-consuming, it's exhaustive, it's transparent, and it is very, very data-intensive. So these data requirements will lay out in very specific detail what must be submitted in order for you to register your new pesticide, your new fungicide, your new antimicrobial, whatever. Every bit of those data are reviewed by EPA scientists. And if those data are determined to be inadequate, EPA will say these data are inadequate or they don't conform to the standard. We're rejecting these data, go back and do it again. So, and the agency's been doing this a long time, so they know exactly what they're looking for. EPA also has discretion to limit the data that are required depending upon what you want to use those data for. For example, if you have a chemical that you're only going to be using in a greenhouse, as opposed to wide dispersive uses in agricultural settings, EPA might waive some of the data requirements under 40 CFR Part 158 because they aren't relevant. But once that license has been issued, you have to stick to the uses set forward in that registration, and if you use the chemical in ways that aren't authorized, that is a violation of federal law for which very significant fines and penalties will apply. So these data are developed and are very important intellectual property of the registrant, or you could have a consortium of companies. You might have 10 different companies that make glyphosate, for example, an active ingredient that is used in Roundup. So does that mean each of the 10 different companies have to separately generate the data to support the guideline that is required to demonstrate the safety of this registered active ingredient? No, of course not. Why would the agency want 10 sets of identical data? Under FIFRA, you can pool data development, similar to what you can do under TSCA Section 4, have competitors come into the same room and talk how they are going to satisfy these data requirements through these chemical consortia. And the antitrust rules are suspended. FIFRA is intended to foster competition, but also intended to diminish unnecessary sacrificing of animals. And so you can pool data. So if you have the same active ingredient with multiple producers, to develop these data, you pool the cost and submit it to EPA as a chemical consortia, and you're good to go. Now, what if you don't own those data and want to get a registration, and you haven't paid any money, but you know that glyphosate is a registered ingredient? How do you get into the market, as it were? FIFRA was intended to foster competition. It was a very explicit goal of Congress in wanting to invite as many entities into the field as possible to achieve a common goal. So while FIFRA allows confidential information to be protected, similar to what TSCA allows under TSCA CBI provisions, you have a right to those data for a time certain, and after which the agency will allow other people to come into the market by providing a mechanism to compensate the data producer for reliance on your data. And similar to TSCA, information is maintained as confidential by EPA, but it's a very narrow pool of information because EPA is very, very clear about the need for right to know with respect to chemicals that are toxins, are designed to kill, and to which you may be exposed as a consumer, as a bystander in an agricultural setting, as an agricultural worker, or so there is a way to protect data, but it's very narrow, and you can maintain the confidentiality and utility of information that will compel people wishing to rely upon your data to procure a license by making them offer you money to compensate you for your very significant investment. And the most typical way this comes up is chemical company manufactures a new chemical, has spent, say, $50 million perfecting the formula, has spent 10 years developing the proprietary information, went through the laborious, extensive, time-consuming process, and has a brand new active ingredient on the market. And it's fantastic. It's low risk, it's effective, everybody loves it. Now, you're a chemical manufacturer and you want to get what that guy wants because they're making a screaming $1 million marketing this brand new chemical that everybody loves. How do you do that? Well, under FIFRA, if it's a brand new active ingredient, a brand new molecule, EPA gives you 10 years of exclusive use to those data. And that means for those 10 years, nobody can rely upon your data unless you authorize it. And then after the 10 years of that exclusive use period, you get a guaranteed market there. You are I mean, that's a very important proprietary right, because nobody can jump into your market unless you say so. So that's huge from the business side of the equation. After 10 years, you still have 5 years on top of that, from the time you acquired your registration, that people have to submit an offer to pay, but EPA doesn't need your authority to get into the market. EPA just has to confirm that the appropriate offer to pay the data owner or owners has been made. And then what happens? So chemical company A has a brand new active ingredient, doesn't allow anybody in the market for 10 years. So for 10 years, you have exclusive, proprietary, single use to develop your new product. 10 years in a day, somebody jumps in and says, I want a Me Too registration. So what that guy has over there, I want. And you submit the offer to pay form to EPA, which is a form. You have to check the right box. Then what happens? Well, then the owner, the recipient of that offer to pay, goes back to the entity that submitted it and says, okay, you owe me $10 million. And that's when these data compensation arbitrations kind of get off to the races. Because the goal under the law is to inspire competition and ensure that entities can get into the market to ensure that products are manufactured at a rate and at a cost that is competitive, while rewarding the innovator for their investment. That's the offer to pay part, and protecting their confidential proprietary, new pixie dust. But after that point, then it's just a negotiation between the parties. EPA tends not to get involved. And if the parties fail to reach a resolution, a business resolution, you can go to what we call a data compensation arbitration, which has all the makings of a trial. You get witnesses, you have discovery, you get people that will come in and say the value of the market that has been developed by this new product is worth $100 million, and half of that market is worth $50 million, so data compensation is $50 million. So you go through this arbitration process. It's not a judge. It can be a retired judge. It can be a lawyer. It can be a former EPA regulator. There are people that are knowledgeable in the area of pesticides. And it's a wonderful mix of law, economics, public policy, and business. So if you really like this space, it's a great area to get into, because data compensation arbitrations, arcane area of the law, but have all the drama of a for real big-time litigation. The rules are slightly less aggressive in terms of evidentiary process and all of that, but you get cross-examination, witness list. Data comp arbitrations can run into the millions of dollars depending upon the stakes of the game. So if you have a big data package, a data comp can be a multi-week or month full evidentiary hearing on the record with 3 or 1 arbitrators, and it's at the election of the parties to have 1 single decision makers or 3 arbitrators. Most people on the big items go for 3, believing that putting all of your eggs in one basket is never a good idea. So data comp arbs are lots of fun. Here is, I just want to give you a sense of what the pesticide label looks like. You might not be able to make out the fine point, but every one of the words, every field, every panel, all the artwork, the size of the font, the color of the font, any logos or icons are all subject to federal law and are negotiated between the registrant and EPA, and are all subject to very specific, very granular requirements set forth in the CFR. So whatever these conditions are, dictate what you can and cannot do with your product. And if you go beyond the specificity here of your label, you're in violation of federal law. How does EPA manage this process? Unlike TSCA, where you submit a pre-manufacture notification at the end of 90 days or longer, depending upon how long that review process takes, the agency will give you the results of its review. Under FIFRA, depending upon whether it's a new active ingredient or a new use of an already active ingredient, all of these are dictated by specific categories set out under the Pesticide Registration and Improvement Act. PREA, as it's called. And PREA is a wonderful law that gives registrants much greater certainty than existed in years past. Previously, before PREA was born, a number of, like maybe 10 years ago, you submitted an amendment to your label. You said, gee, EPA, I've got this registration, I've got this license, but I want to amend the license because I found my product can now be used on lemons. And the label doesn't allow it to be used on lemons. And I can make a lot of money killing critters that, attack lemons. So please, here is my registration amendment. Before PREA, there was no specific time frame within which EPA was required to review and either approve or disapprove that amendment. So PREA, depending upon what the amendment is, whether it's a new use or a different application rate or a new active ingredient, dictates what bucket you fall in. And I think there are maybe some 80 different buckets. And you will know how long EPA's review takes, 3 months, 9 months, 18 months, 24 months, and what the cost of that is. So unlike TSCA, FIFRA is a little bit more of a pay-to-play. And a new active ingredient can cost a lot of money. $500,000 is the fee, not the data requirement and not the consulting fee, just EPA's fee for reviewing the information you are submitting to procure whatever approval you are seeking to procure. But the good news for businesses, there's a good deal of predictability, and you can go about manufacturing your new chemical, get your new label, and you have a sense of how long it's going to take, which is critical for managing your business. And EPA has done a really good job of sticking to those PREA deadlines. And I think Jim Jones and his colleagues at OPP, which is now under the direction of Jack Hausinger, should be rewarded for their ability to manage these deadlines in a way that provides predictability in the business community. In addition to just the business of managing pesticides, ensuring that the data that support them are reviewed and considered, that chemicals that are reviewed and approved by EPA are reflective of a solid science package on which those approvals are based. EPA is also very diligent in promoting safer, so-called reduced-risk pesticides. To incentivize that market, there are reduced fees under PREA. You get expedited reviews, which I tell you, the difference between 6 months and a year in the business community can mean millions and millions of dollars. So having a chemical that falls into the reduced risk category can mean an awful lot to your business plan and your sustainability. So EPA has made it a priority to incentivize the submission of reduced risk, safer pesticides. And how that happens is all laid out with granular clarity on EPA's website, and I won't belabor that point here, but recognize that just as EPA's Industrial Chemical Office is focused on incentivizing design for the environment, molecules that are safer when used as intended and offer fewer environmental and human health risks, so also EPA's Office of Pesticide Programs to develop and incentivize the replacement of more conventional chemicals that maybe could be amenable to a less toxic potency. EPA is really focused on incentivizing reduced risk conventional pesticides and does so in a very material way through reduced fees, expedited reviews, and dedicated resources. FIFRA enforcement, not unlike TSCA, are very extensive. Administrative penalties, civil lawsuits and penalties, criminal penalties. EPA also under FIFRA, similar to a ban under TSCA, EPA under FIFRA can issue a stop sale order where it says, we have reason to believe that your chemical that you are marketing under this label either does not conform to the active ingredient and the limitations set forth in your pesticide label and the supporting what is called confidential statement of formula, and you have to stop right now. They'll red tag the product and further distribution of that chemical is absolutely impermissible. So that's a very draconian tool for EPA, not surprisingly, because if you're in the business and you're marketing a pesticide, if you get a stop sale order, it means you stop right now. You embargo the existing product, you can't distribute anything in your warehouse, and you might need to recall product that is already in the channels of trade, all the way down to, depending upon how, well, how big the problem is, EPA can make you get it back from very seldom the actual user level, but certainly the retail level, the warehouse level, all the way back to the producer. And then what you do with that product, whether if it must be destroyed or can it be reformulated, are all provisions that are dictated by EPA. Civil penalties, criminal penalties, of course, can be very significant, and EPA has stepped up considerably its enforcement of pesticides, recognizing that heretofore it has not been an area of concern as much as TSCA, but there are many more FIFRA enforcement actions today, either derivative of violations of the so-called treated article exemption. In other words, people have made too much of the exemption and are now making claims related to the pesticidal potency of products that are not registered as pesticides, but don't fall squarely within the exemption from registration under the treated article exemption, because the product suggests to a consumer that it has a pesticidal or biocidal or public health attribute that really would require a pesticide label to assert. So that's where a lot of the enforcement action is right now, in treated violations of the treated article exemption, people being duped into thinking that a product that might contain an antimicrobial is extolling public health value that it really doesn't, and the agency has been very focused in stopping that. And of course, just any product that does not conform to its uses and limitations will be a violation of FIFRA, and EPA will use its own enforcement staff in the Office of Enforcement and Compliance Assurance, and it will deputize state folks at the state level to go out and discharge some of those enforcement functionalities, because there's a lot of chemicals used in a lot of different states. And also, if you are a registrant under a state law, like the California Department of Pesticide Registration, you too will be subject to state enforcement in addition to EPA Region 9. So you're looking at just not federal enforcement, but you could also be looking at a state violation as well. So that brings us to the end of our FIFRA piece. I wanted to see if we could now have a robust discussion about pesticides, how they're registered, what the administrative process is, any differences between TSCA and FIFRA that you'd like to talk about. Pesticides are always a hot button issue, many different issues relating to environmental justice, the wide dispersive use of pesticides, and how can we be certain that pesticides are not inadvertently wandering off the target site and impacting bystanders or others. I spend my weekends out on the Eastern Shore, and I love to watch the aerial application of pesticides, with the what look like Snoopy prop job planes that kind of come what seem to be so low you can touch them, deploying pesticides right next door to me, completely legal. But, it gives rise to a lot of questions about, well, golly, am I inhaling that? And, all of it is subject to very strict federal and state regulation, and it wouldn't be done if it were causing harms, but it does give rise to a healthy debate in rural environments about whether this is what we should be doing, or are there better ways to do it, hence EPA's incentivizing of reduced risk pesticides. Any questions from our audience here? Because we've got a couple of questions that have come in from our listening audience, one of which is, are TSCA and FIFRA like the Clean Water Act in that it allows for citizen suits? Good question, good question. Interestingly, TSCA does allow for actions brought by citizens under petitions derivative of TSCA Section 21. FIFRA, however, really doesn't, is a little bit different in that you can challenge final agency action and challenge EPA's decisions under FIFRA and sue EPA for what you believe to be a violation of the standard that they applied in reviewing a particular chemical and resulting in a particular action. But you can't bring a citizen action against a registrant under FIFRA. That's not the way that it operates. The question goes on to say, or more generally, how can a community or person who is believed to be harmed by a toxic substance use TSCA or FIFRA to seek amends or recourse? Well, certainly under TSCA, you can, under Section 21, bring a petition. You can urge EPA to take a particular action. You can challenge EPA's decision with respect to an action under FIFRA in either approving a particular chemical substance or a significant new use rule. You can challenge that in court. Not a particularly easy or inexpensive option, but it is there. Similarly, under FIFRA, you can, most importantly, engage early and often in the process. Both TSCA and FIFRA are very transparent with regard to the opportunities for stakeholders, read broadly, to participate in the process. So if you are a citizen activist or an NGO or just a stakeholder or a competitor or a manufacturer, it is incumbent upon you to participate in as many opportunities early and often in a process to ensure that EPA is following the rules, that the level of information, the quality information comports with the standards set out in the law and the practice that has evolved, and participate in that process and ensure that the result reflects as many of your concerns and aspirations as possible. If that turns out not to be the case, you can sue EPA for violation of the law and the Administrative Procedure Act and bring an action in federal appellate or in some cases district court to procure a result. You can file a petition, as I said, under TSCA Section 21, urging EPA to review a particular chemical or course of conduct. So there are lots of different ways that stakeholders and relevant others can participate in the process, and certainly engage with EPA and state offices as appropriate to ensure that if there is a concern out there, that you are bringing it to the attention of those that are in a position to address that concern. There's no dearth of opportunity to participate in either of these laws. They're risk-benefit statutes. They very clearly define safety standards, and much of the information is publicly available through the dockets that are now almost routinely available online. And EPA goes out of its way, in my view, to make as much of this information clearly open, accessible, and available for review to ensure that all of the opportunities available for public participation are maximized. Other questions? Yes?
How is the risk standard usually proven for food uses with pesticides? So I guess the standard is no unreasonable risk of harm.
Right, right.
So how is that usually demonstrated? Is it animal studies, or do they do like person testing?
That's a good question. The question is, how is the food standard demonstrated under FIFRA? So in other words, you have a pesticide that is applied for food uses. You have to demonstrate that there's a reasonable certainty of no harm. That standard is discharged by reliance upon a very extensive battery of tests that includes largely animal data and other predictive methodologies that will demonstrate that whatever the standard is and how that is quantified for purposes of that particular active ingredient meets that standard. It's robust, it is science-driven. It might rely in some instances on human data, but human data is not typically allowed without a lot of different protections provided for the subjects of human testing because of ethical standards that are very rigorously enforced by EPA. So it's largely animal data and other predictive methodologies that are set forward under the rules. And with that, we have reached the witching hour of 2 p.m. here in the East Coast. So I want to thank our viewing audience here and our listening audience, and on behalf of the Environmental Law Institute, thank you for your interest in TSCA and FIFRA.